and I've known Usha for a very long time. We actually went to the same college very long ago. And it's really nice to see how active she has been over time. So, okay, so I have sent all of you, I hope some of you have managed to open some of those readings, 4 readings actually, and the PPT as well. If some of you have had the time and energy to open and look at that, that will help us a lot, because then you know where I'm going. And let me first and foremost say that I'm not a lawyer. I've never been a lawyer. I hardly know anything about law. But I was invited by your university to speak on research methods, and it took me some time to figure out what is it that I could possibly say which could be of some use to you. So I'm an economist, and I'm a researcher by training, though of course at the Ahmedabad University I teach and some courses. Particularly I teach development economics, and I teach kind of a hands-on course on the urban informal economy, a lot of which is part of my research work. But my joy is in doing research, and in order to give this lecture to you also, I did some research, in the sense that I hunted out a couple of lawyers, including Usha Ramanathan, and another lawyer friend of mine, which is Kamala Shankaran. I think she was heading your Tamil Nadu University, and now she's originally from Delhi University. To see what kind of research work is actually done in law, since I really have no clue. And then I have a friend and a colleague at Ahmedabad University who teaches law and economics, and he has also done some work, which one of those studies we will be looking at, Karthik Rao Kavale. So I sort of tried and found a few studies which talk about law, and basically the focus will be on research methods that these studies are using. It's not on the law, because I don't really know the law, that particular law. I might be talking about the insolvency bankruptcy code, or I might be talking about rape law, or I might be talking about the law of street vendors and so on, but I really don't know the law or what are the proceedings in a court. But then what are the kind of research that you can do, and what are the research methods? And in each of these papers, so instead of, I see that you have a lot of lectures coming on telling you how to frame a question, how to frame a design, how to do empirical research, how to, almost everything that anybody can teach in a research methods course is being taught to you in this thing. And then, of course, you have 2 more such rounds of research coursework. But so then I thought, like, how can I add anything to what you have already learned? So I'm not going to teach you the method, but I'm going to show you a direction in which the method can be used to do particular kinds of research in law. All right, so I will start by sharing my slides. Okay, has the slides come up? Can you see the slides?
Yes. Yes.
Okay. So like they said, I'm a professor of economics at Ahmedabad University, and I teach economics. And this particular thing, I wanted to term it as empirical research methods in social sciences, with special references to research in law. So there are a few papers in law which we do, which are related to labor. As the introduction would have told you, I am a labor economist. I specialize in labor. So I just know a little bit more about labor, not necessarily about labor law. All right, so to give you a broad framework, which of course everybody will be telling you, that what are some of the key things that you should look out for when you are thinking in terms of writing a dissertation or writing a thesis or even writing a paper. I mean, this is all very simple. Obviously, you have to find a topic, and the topic has to have some relevance or some significance to what's happening in the world around us. Then the important thing to be able to do before you start, once you have chosen a topic, is to do a review of literature. Now, I see that you have sessions on review of literature, but they'll tell you, so they will tell you what to do and how to do it. But my point here is that the review of literature will actually tell you what has already been done in this field. So whatever law you take up or whatever topic you choose, what is the kind of literature that has already been done in this field? And from there, we generally tell our research students, and not just research students, even when we write papers, we send papers to journals, we have to show what is that extra thing that we are going to do within that frame of set of research, which is already done. Because none of us are Einstein or Newton. We are not producing something absolutely new. We are only going to stand on the heads of and shoulders of people who have already done research in this area. So it's extremely important to find out what is the work that has already been done. So that review of literature is an extremely important part of your planning for a research topic, planning for what is it within that research, broad research topic that you want to talk about or you want to do is that important. So once you have figured that out, then the question that this review of literature is also going to help you to do is to frame a research question or frame a research set of research issues. Without a research question, let me tell you, you're lost. Because there's so much of material out there. Even as I show you any particular papers, you'll see that those papers can be taken in almost any direction because of the amount of data that exists there. So unless you have a very clear research question that you want to investigate, or a set of issues that you want, not just one question is a broad question, and then you have a lot of sub-questions within that, it will be very difficult for you to focus onto anything and be able to come out clearly from any data that you might collect. Then, of course, the research methodology. So then you have to choose. So that's basically what we're going to talk about. What exactly are you going to do? How are you going to do that? And what is the data? So by statistics, I mean, what is the data that you're going to use there? And by model or framework, so this becomes very important for economists like us, where we have to figure out what is that, basically what is the theory, what is a broad framework within which you're going to be working. In law, I'm not exactly sure how you visualize theories. There must be theories in law, and what kind of a framework you are working in. So you have to broadly sort of think about it, define it, and speak about it, write about it, and so on. And data is, of course, because I'm talking about empirical research, data becomes a very important thing. So we will talk about what kinds of data, what is the nature of data, and what is the nature of a couple of research methods that you can use. Of course, in law, your lawyer professors will give you 100 other ways of doing research in law, which is basically based on law, case law, and so on and so forth. But that's not really what I'm going to talk about. Then, of course, you have all your substantive chapters, and that's the body of your research, and you have to decide what all you're going to, what are going to be your chapters there, and then describe, use this data, use this methodology, describe the results that come out in each of your substantive research, and okay, and the rest of it is very simple. All right, so my concept, I'm going to focus only on defining a research question, less so because you have a lot of classes already telling you research question, but research methods that particular studies have chosen. And I have chosen a couple of studies, 4 studies basically. I hope I'll have the time to go through all of that, most of it. Some of them I've kind of tended to put it in more detail, particularly the ones that are extremely descriptive. They're more difficult. For me, they are more difficult. I'm an empirical person. I use large data sets. I do data crunching using software. So I'm much more comfortable with that kind of data rather than the qualitative data. But I am going to talk about a couple of qualitative data, qualitative studies that we can look at. Yeah, I'd like to say that, I'm a professor and I can speak for 1.5 hours straight. Not a problem. But I would be happy if you would interrupt and ask questions or tell me that you didn't understand. And, it's quite possible that I won't be able to answer your questions, but at least we will be able to, at least I'll be able to understand what is it that you have understood or not understood. Right? So you're most welcome to interrupt me anywhere, anytime. I have no such issue that I have a kind of thread of thought which I lose if you interrupt, not at all. And in any case, we have the slides to guide us. We can always go back. So basically, in terms of research methods, again, let me tell you that there might be a lot of other methods which law theses use, which I'm unaware of. But broadly, I would, club the kind of research methods that you could use into qualitative and quantitative. Now, each of this is, is a Pandora box, and there are hundreds of methods within that. There are hundreds of softwares within each of them, and each discipline uses different methods within qualitative, within quantitative, and also different software also within qualitative and quantitative. So we can't go into all that, but broadly, we can have qualitative methods and quantitative. Now, what do we mean by that? So by qualitative, is it a lot of this work is, they call it social-legal studies or ethnographic. By ethnographic, we simply mean, of course, ethnography is a discipline in its own right, and it's used a lot for us as social scientists, it's used a lot in anthropological research. Ethnography is also used in economics research, and it is quite, very well used in law as well. So basically what it means is that it's a qualitative method. What it means is that you observe and interact with the participants of your study. So if it is a law, if it is a court-related thing or out-of-court related thing, then you are observing what's happening there, and you are also taking interviews and in-depth interviews and unstructured interviews with the participants of this study. So that's the kind of an ethnographic. You can have case histories, you can have oral history. There are a lot of methods which you will see some of them coming up here in the two papers that we're going to talk about, which are qualitative. Case law, of course, you people understand, I don't have to talk about it. Ethnography also involves tracking cases, not just inside the courtroom, but outside the courtroom, and following the processes which are happening in the court, observing, coming up with, following your question, your idea, your thought, your framework, and so on, trying to understand what is happening in that court and among those people. So this is the kind of qualitative method. It's a lot of it is descriptive. Now there are software also for that. So I don't do much qualitative research, but I see my colleagues doing it. So if you have a very detailed interview or a very detailed discussion with one of your participants in your study, then you can use this software to, you arrive at certain keywords that you're interested in. You see how many times these keywords are being used. So you get an idea of what is the main theme of the discussions of these long transcripts. So we do some kind of, the management discipline does case studies, which are a documentation of, say, how entrepreneurs, particular entrepreneurs, how they have come into that particular business project which they're doing, how they have grown and so on. So they do very, very long interviews and they create transcripts, they record them, they create transcripts, and then they use this software to be able to sort of very systematically analyze that data rather than just read it and so on. So similarly, in economics also we do case studies in a slightly different fashion, also oral histories and so on and so forth, which also you can use some of these softwares. See, originally we never did that. We just did it sort of manually, but now there are softwares which help you to do this understanding of the descriptive ethnographic stuff, the data that you might be collecting. That is also data. And in the quantitative, this thing here, you have hard data where you are actually, maybe you focus on a particular law, which is what we're going to do in our two quantitative studies that we're going to look at. And then you look at the legal process this going through, and then, your courts and your court tribunals and so on have databases of all the cases. And in that, you get a lot of information, which is quantitative as well. Or you can convert them to quantitative. So things like when the case was filed, what are the dates? Now, the one that we do on IBC is basically doing that, the Insolvency and Bankruptcy Code paper that we will take a look at. So whether there was arbitration, whether it was resolved in court, whether that case is pending, how long it has taken, how many times they've actually had a court session, and so on, all that can provide you very interesting information about that case. So that's one way in which they do this. And the other thing that we can do is take a particular law and try to assess the impact of that particular law or the effect of that particular law. I don't know how much of lawyers do this, but in economics, we do a lot of this because there is a very growing field which is called economics and law. And in that, we would take up, so the last study that we do is that actually it is on labor regulation. So a particular labor regulation has been taken and they compare across states the impact of that labor regulation on various economic indicators. So you might not understand all those work in indicators, but that is another way of doing it. So you're basically trying to understand the impact of a particular law over a period of time. So that is, really using hard data. So there are many ways in which quantitative methods can also be used and be used in your law. Okay, does anyone have anything to say before I get into the actual cases, the papers that we're going to look at? Okay, so to just broadly go over what are the kind of possible data sources which exist. So court websites is probably what you know best, and you probably know a lot more about what exists in them than I do. But then court, as you know, is at various levels. You have the Supreme Court, High Court, and you have all kinds of subordinate courts. Like I definitely know that there are labor courts. Then there are law commission reports. I looked at some of these law commission reports, which talk about all kinds of things. Sometimes they describe an act and how that act has come into being and so on. And sometimes they give you all this information about a particular law or a particular act. Then the other way of looking at various laws is, which again is done by a lot of social science people, is looking at police records. I'm not sure that police records are extremely well maintained, but police records in terms of you're choosing a particular law, right? And then what are the kind of FIRs filed there? What action has been taken? You could look at criminal cases, depending on what law you decide to look at. You could look at domestic violence cases. You could look at rape case. We actually look at one rape case in a qualitative fashion. Then another data source that is used, again, also used by people like economists and social scientists, are the National Crime Record Bureau. So a lot of it is criminal law. I'm not sure whether civil law and company law is recorded over there, but crime records, maybe fraud is recorded. Another interesting data source is this armed conflicts law. And incidentally, recently we were doing a paper on citizenship and looking at the Citizenship Act. And then we came across this thing called the Armed Conflict Location Events Data. It's called ACLED. And this actually records the number of political violence and protest, riots and protests which have happened across locations. So they take cities within India. I mean, I think it's an international data source, but in India, you can look at cities and states and record the number of violences that had happened. So this is, one set of data with regard to the law, and then you need to look at other sets of data and then see how this plays out. I mean, what is the impact of a conflict or a violence and protest on some issue that you would like to study. So that's another data set. And eventually, because none of this is complete, you will be creating your own data set, which I'm calling manufactured data set. So creating your own data set, you can create it from all these sites, depending on which law or which issue you plan to, what is your research question that you plan to talk about. And you can also create a data set from your primary data collection. Like I said, you're tracking cases, or you're looking at historical data, or you're looking at newspaper archives, which is also one of the things that the first paper that we're going to look at is using newspaper records of different kind of events related to a particular law is also available. It's available online as well. So that could be something that you could do. And then depending on what your idea is, what your research question is, what your method you're going to follow, you can create a data set. So you have different variables. So in economics, we talk in terms of variables. So like, for example, if we were taking this armed conflict, then we would say the number of violent incidents that have happened, which is protests or riots or anything like that in a city or in a state. So that could be one variable. And then you would have other variables which might be affected by this conflict or which affects this conflict. And then you can analyze that. So similarly, in this case, like when we do the IBC, you'll see that they take records of under the IBC, which is a new law, 2016. What is the case records there? So pending cases, how many have been completed, and what is the jurisdiction, in which part of the country these cases came up? What is the debt? What is the amount of credit and debt which is being recovered there? Because the IBC is a Insolvency Bankruptcy Act. So so you basically then you create a data set of your own, and you would need to do that even if you are doing qualitative data or quantitative data. Depending on that, you create this data set, and then it's that data set that you will use to be able to analyze. So we are talking about empirical research, okay? Right. Okay. So now, if nobody has anything to say, we'll go into, I have recorded 3 here. One is Usha Ramanathan, which I'm not going to talk about. She has this paper in Economic and Political Weekly. She has a number of papers, if you Google her, on law. And here she's talking about beggary law. It's also a kind of an ethnographic study. But I will not be talking about that. I will talk about these 2 studies. One is by Karthik Rao Kawale, and it is about street vendors. And he talks about the art of buying time, street vendor politics, and legal mobilization. So he's basically talking about legal mobilization as a strategy adopted by a collective organization of street vendors. So it's not an individual, filing a case, but it's a collective filing the case. That's one of the studies we will look at. And the second one, it's a very qualitative, descriptive kind of historical data study. And the other one we will look at is by Pratiksha Bakshi, which is about a particular rape trial. And she's using a kind of an ethnographic method to look at how a compromise takes place in rape trials and how compromise is not actually allowed in the rape trials, but then how they arrive at that within the court. All right, so now to come to our first study is this study on street vendor politics and legal mobilization in India. So he basically looks at 2 cities. One is the city of Bombay and the other is the city of Chennai. And he looks at it over a period of time. And then he looks at how mobilization of street workers happens and how they finally go to a legal solution, try to look for a legal solution. That's why he's calling it legal mobilization. So it's a very descriptive kind of way in which he has written this article. And it's actually part of his thesis. He did his thesis from MIT. It's surprising that the Massachusetts Institute of Technology in Boston has these kind of political economy theses as well. What the position he's trying to take is that, are these courts and this judicial process that they follow, in that process, do these courts become agents of change, agents of progressive change? And he actually kind of questions that. And then, like I said, you kind of have to figure out what is the broad literature and what is it that you want to do within that. So in that, he looks at what are the consequences and causes for this legal mobilization. So it is legal mobilization of whom? It is of the street vendors, right? And why do they approach the court, or rather the collective actors? So it's not each street vendor approaching the court. It is this collective of a street vendor organization which is supporting the court. So then the person who's approaching the court is what he's calling this collective actor, and he's approaching the court on behalf of this marginalized group, social group, which is, in this case, he takes the case of street vendors. So there are many such studies of legal mobilization, and within that, he is taking the case of street vendors, street vendor association. But what he's trying to argue that, in order to evaluate what happened in that process of legal mobilization or going to court, why did they do that? I mean, what was the reason they went there? So there must be some kind of a historical, political context in which that happens. So if you want to understand how good that litigation was, whether it came up with good consequences, whether it was a progressive move or not, if you want to understand why, you have to also understand under what circumstances they were forced to mobilize, and they were used for this particular process of a legal solution. Why did they approach the judiciary in the first place? So that is his point with regard to evaluating the impact of this kind of a procedure. And then one of the reasons he cites is that maybe the collective that went for this, they approaching the court, they find that it is a slightly more long-term solution, because otherwise they also negotiate on the ground. See, they negotiate with the municipal corporation, they negotiate with. There are a lot of dadas operating on the streets, among the street vendors, gathering hafta and so on. And since I work a lot on informal work, I see a lot of this kind of activity happening, and I've met a lot of organizations which work with street vendors, and you see a lot of harassment happening there. So there is a negotiation which goes on the ground with the police, with the dadas, the ones who collect hafta, with the municipal corporation, with the municipal councillors, and so on. They don't always go directly to the court. So what makes them go to the court might be that so all of these have some kind of impact. Even if you're negotiating with the local gundas, or you are negotiating with the local police, you have some kind of a short-term solution comes to the problem faced by the street vendors. But for getting a more long-term solution, a slightly more cumulative long-term benefits, maybe these organizations feel that it might be useful to go through the judicial process, and that is why they probably approach the court. Okay, so now since I'm talking about data, what is the kind of data source that Karthik Kavale is using? So he's basically using different kinds of documentary evidence. So how is he getting this? So he is basically using 3 sources. So please pay attention. This is the kind of one kind of data that you might be able to collect in order to look at any law. Here at this point in time, we are just looking at street vendors, okay? And the final solution to this street vendor thing is that a Street Vendor Act comes into being. But that comes into being only in 2014. And he's investigating a much earlier case. But then all this activity which is happening in the various cities among the street vendors actually finally leads to the act. So you can also have now, today, look at the impact of having that Street Vendors Act passed in Parliament in 2014, I think. So that would be a totally different study. This is like prior to the Street Vendors Act. So what does he look at? He looks at legal documents, which he obtained either from public sources, like all the sources that we talked about, court records and so on, but also from directly from the people who did this, the petitioners and the lawyers who worked with these street vendor organizations. So legal documents is one of the documents which you will be using, all the time. The other interesting source that he uses are newspaper archives. So the Times of India, incidentally, is an extremely interesting archive, which is online, and one should be able to get access to that. I'm sure your university will be able to get access to that if you are interested in that. So we have a student in doing her MA in economics at my university who has looked at the Times of India archives to look at what happened during the pandemic of 1918. So the records are there till that long ago. So he also uses this data. So what you are getting are newspaper reports of what has happened within the street vendor movement in different points of time. So you use that, and like I was saying in your qualitative research methods. I don't think Karthik might have used that, but he might have. He uses certain keywords, and then you can actually look at those, the newspaper records and try and find out what exactly is the theme and what is the thrust of these events which are happening with regard to street vendors in these two cities of Bombay and Chennai. For Chennai, he actually used the Hindu, the newspaper The Hindu, but not from online records. Times of India, he used online records, databases, and in the Hindu, he actually went into the library and used the librarian of the Hindu to be able to ferret out these records. So he basically uses these search terms, and since he studied in MIT, I'm sure he has used one of those softwares in order to be able to extract this information about the street vendor legal mobilization over a period of time. All right, and the third data that he uses are oral histories. So oral histories are basically interviews, very in-depth interviews. So that's why this thing becomes, in that sense, ethnographic or a qualitative research method that he has used. He collected data from street vendors, leaders of these street vendor organizations, and then lawyers who represented them, represented these street vendor organizations. So one of the things that one has to do in any kind of research is what we call this word here, triangulate. So now what is the meaning of triangulate? So here, of course, he is using various sources. So various sources might actually give us, conflicting information also. So in order to be able to validate and to find out whether which of these this information is correct, including the records, because journalists are writing these things in the Times of India or in the Hindu, you basically verify this factual information. That's what they're calling triangulation. Through these, talking to these people who are mostly older people who are either street vendors and have watched and have participated in some of these events, and the street vendor organizations and the lawyers who have actually represented them. Even in the kind of research that I do, we do triangulation, which is like if you have a particular topic, okay, you're working on entrepreneurs or something like that. There are like 3 different data sources that you can use, hard data sources, and arrive at a relationship between why women entrepreneurship exists, and what are the determinants of that. So when we say triangulate, we, in that hard data kind of way of doing it, the quantitative way of doing it, we will try and address that same question through 3 different data sources. And then we'll see whether you get similar results or you get different results, and how different are these results. And then if you are getting similar results in these different data sources, then you can say that, okay, now you have verified your so that's what we call triangulate, because here you're collecting data from various records, and then they are likely to contradict each other and so on. So you still have to validate and find out how to do it. So now the method he uses is to study the history of the politics of the street vendor movement, and from the 1960s. So in 1960, this Bombay Hawkers Union was formed by George Fernandez. Now, I'll not go into the history of George Fernandez and so on. I'm sure many of you have heard of him. He was a very famous, vocal trade union leader. And later on, he became a minister in the Janata government. And he was, I think, right. But then in 1967, the Shiv Sena, which was a relatively new party at that point, it's son of the soil kind of party, they came in and started to, have some kind of a very ruthless, violent campaign against all trade unions in the city. And the hawkers were also targeted because many of these hawkers were Muslims were migrants coming from different states. So this anti-hawker rhetoric, so while they were playing this anti-hawker rhetoric, the Shiv Sena, they were also creating new hawkers, giving licenses and so on, to create competition for the older ones, and trying to capture the most lucrative sites. So if you're a street vendor, if I stand here outside my house, I'm not going to get any business. So I need to stand in some part of the street where there is a lot of traffic, where people are moving. And only then you can, so that lucrative, that site becomes a lucrative site. So capturing lucrative sites is part of the game in this, kind of way in which the street vendor organizations and street vendors operate. In the 1980s, in the beginning of the 1980s, then, so obviously you can see that there's a number of unions coming up there, and the people started to leave the Bombay Hawker Union, and many splinter groups were formed, very often under particular politicians. Okay, so now to come to the law and to the judicial process that was followed. So now a lot of emphasis in the literature has been given to this 1982 judicial intervention. So the Bombay Hawkers Union, which was kind of dwindling at that point in time, in 1982, approached Indira Jaising. You all know Indira Jaising better than me. She's a human rights lawyer and very, very active. So through her, they filed a writ petition in the Supreme Court in 1982. So what they were asking for in that particular first writ petition was a slightly big thing. It was kind of challenging the constitutional rights of the municipal corporation, that is the Municipal Corporation Act. The Municipal Corporation Act allowed the municipal commissioner to to arbitrate and to decide on the distribution and the renewal of licenses. So for hawkers to be able to get good business and not to be harassed on the street, they require a license. Now that's the whole politics of this. Licenses, how many of them are issued, how many hawkers are there actually. So they were actually challenging and wanted to diminish the powers of the municipal commissioner with regard to the issue of licenses. Obviously, the Supreme Court was not in favor of that. And in the early hearings itself, they figured out that this is not going to work. So then they filed another petition, which was less ambitious. And they basically said that there should be some kind of a scheme to accommodate the street hawking. That there should be, like places, vending zones and so on. A lot of things can be done for street vendors. So they sort of asked for that. And that was kind of court sort of agreed to that or liked that idea. And what they did was, now I don't understand this language, but sought to adjudicate the dispute using a procedure which they dubbed non-adversarial. So that wherein the court suggested that the municipal corporation should evolve some kind of a solution to the problems, which was, good on both sides, both for the hawkers and for the city dwellers and for the municipal corporation. So in that process, the municipal commissioner then issued like 49,000 licenses and sort of demarcated certain hawking zones within the city of Bombay. So now this has been seen, this particular judicial process, which was followed in 1982 by the Bombay Hawkers Union, has been seen in the literature as a huge success towards, sort of going into this area of socioeconomic rights for this marginalized group of workers, which are the hawkers, and provided a new opportunity for urban social movements to benefit. So it was like a case where they said that this is one of the great things which has happened in 1982. Now the rest of the paper, Karthik Kavale is trying to argue that this is not true. The 1982 case was not the case which allowed for this legal mobilization situation to start or to develop, or for this movement of social street vendor organizations to develop. And that's what he does in the rest of his paper. He contends this fact that, and he says that we should look at this within the broader historical and political events that were happening at that point in time. So he says that this is not the first instance when this happened. Earlier in the 70s as well, it has happened. And the only thing new was that in this new thing which had started, I believe, the public interest litigation, that made it a little easier for these kind of political groups to approach the Supreme Court. And as we know now, PIL is one of the big things which goes around for rights activists. So then he argued that this so-called argument that in the 1980s, with that case, there was this shifting of this legal consciousness and the whole idea that, does somebody want to ask a question? Is somebody trying to say something? Shubhi Trivedi's name is showing up here.
No, ma'am. There is no question from my side.
Okay. All right. So what he is arguing is that the language of rights was used much earlier. Even in the 1950s, the street vendors had started to use this language of rights, and they, in fact, in the 1960s, the Bombay newspaper, because he was looking at these newspaper records, the municipal corporation and the journalistic world, there was a debate on whether there existed a right to trade for street hawkers. So as you know, most of the urban elite don't want these hawkers on the streets, and the hawkers, for them, it's a livelihood. So do they have a right? Do they have a right to livelihood? Do they have a right to trade? So in the newspapers, in the 60s even, there was a debate. Now this debate has to be triggered by something, right? So that kind of a consciousness was already developed by the street vendors, and the unions, the hawker unions, had already been fighting policy battles with the municipal councils, not just on the ground street fights for occupation of remunerative spaces. They were also fighting legal battles, sort of not legal, but policy battles with the municipal corporation. So this legal consciousness was not something that came in the 1980s, according to Karthik. And then that the Bombay Hawkers Union of 1982, were they really able to achieve anything so great as is being declared in the literature? In the sense that, according to him, it only created a status quo situation where there already were licenses, and only thing that it might have done, Indira Jaisingh's filing of that case, was to institutionalize the process through which licensing was happening. So it kind of forced the Municipal Corporation of Bombay to go through a process of, a more systematic process of issuing licenses. So that institutionalization of the process of licensing might be one of the things that was gained by this 1982. But as far as creating legal consciousness, social movements, or being the most important legal battle that was fought, Karthik Rao does not agree with that using his historical data. So what he suggests is that going to the judiciary or filing a case is really what happens only as a last resort for marginalized group. They will try everything else before they think in terms of going to court. I can't see the top of this. So then he gives a whole lot of cases, but I think I'll have to move forward to the next one. He gives a lot of cases as to the kind of the on-the-ground fight which was happening with the Congress coming in, the emergency, the kind of problems that the hawking people were having. So this was actually the background under which that particular case was finally filed. Hawkers Union did approach. So what he's saying is that in 1982, while they approached through Indira Jaisingh, the first time that they went to court was not in 1982. It was actually in 1974. And in 1974, they actually went to court for a single member, not for the collective of hawkers. And because this person, this single hawker, actually had a valid license, and he had been removed from his place of hawking and was not allowed to hawk. So the lower court was unsympathetic, but the high court ruled in this that the police action which had been taken against this single hawker was in excess of the authority granted by law. And in that process, 200 hawkers who had been evicted were returned to work. So he is trying to show that the 1982 case was not the first case that went into court. In 1974, there was this case of a single person, a single case which was taken up, basically. Okay, So finally, what was the result of this whole process of legal mobilization? What they are doing, according to him, is this judicial process is really a process of last resort, because as you know, all of you as lawyers, the case doesn't get solved very quickly. So what they really do is file this case, bring stay orders or whatever else you can do in court, because it then helps them to delay the process or to buy time. That's what he says is really what the judicial. But by 2000, a large number of cases start getting filed, because all kinds of groups become active and they start locally putting up cases. So this is what in the literature Charles Tilley and Sidney Tarot call an upward scale shift, which means that what was just a small problem there on the ground between the hawker and the police or whatever becomes a kind of a larger city level issue. You're upscaling the whole issue. The importance of this issue of hawkers and their rights is really being scaled up by this kind of small litigation which is going on. So with the result, what happened was that the caseloads became too high for these petty disputes. And so then the judiciary directed the parliament to actually establish a system for street vendor regulation, which is consistent with the existing laws. And that is when the one particular street vendor organization, which is called NASU, which is the National Association of Street Vendors of India, and many other organizations, they, as small groups, they start to federate and become regional groups, national groups, and even international groups. And then they started having association with civil bodies, with media persons, and even going up to the international organization. In this process, they were able to get for India a policy, a national street vendors policy. But again, that policy was not effective. So taking this forward, they ended up with now we have finally a Street Vendors Act of 2014, which is a law, and which talks about regulation of street vendors and a whole lot of. So that entire process which he describes was really also the beginnings of coming to a solution, which is the Street Vendor Act. Now, as legal experts, you people can actually talk about the new Street Vendor Act and go forward. Okay, so it's taking me a lot of time to talk about these ethnographic stuff, I think. So now let me just go ahead. Now, is there anything that you would like to ask about the street vendor thing, or basically about the method?
Ma'am, I had a query. So, if I
your voice is a little soft. Please.
Hello.
Yeah, speak.
Am I audible?
If you can speak closer to the mic, it'll be better.
Hello, am I audible clearly now, loudly and clearly, ma'am? Hello.
Okay, you can speak. I can hear you.
Hello.
Go ahead.
Yes.
Yeah.
So, ma'am, all this while when you were basically talking about this street vendor article by the particular author Karthik sir. So the kind of method that the author over here has used in order to come up with the data, right?
Yeah.
That seems to have a lot of historical approach in it. So he is relying on a lot of legal documents. He's relying on a lot of records, and he's relying on case studies. So I just want to make myself clear through your viewpoint, whether I'm boiling it down to the correct thing or not, that the approach that has been discussed in this particular paper is qualitative in a matter that it's only being discussing on the basis of the literature that is present in terms of the records, the cases and the bureau records and the legislations that have. So what I'm trying to figure out that in this qualitative ethnographical approach, it's the method that is used is the historical method by a way of documents and records. If I'm correct, please correct me if I'm wrong.
Yes, it is. So what is your question?
The question was just this only, that I am able to figuring it out the same what you want to convey or not, or is there any
Yes. This is the way qualitative data can be put together. So that is why I'm focusing on this one particular method where you are getting information from three different sources, right? One is your legal records, which is easy for you to understand, and you probably know a lot more about it. But there are these newspaper records and events which are happening, which is also documenting the struggle which the street vendors have taken. It will also be talking about the cases and who participated in it and what were the result of those cases and so on and so forth. So that is one of the things that but what he is emphasizing is that the historical and political process which made these people go to court, that is what he wants to discuss. So it's more in the line of a socio-legal kind of study. It's not a study of the one particular law, right? This is just one of the methods by which you can do research. All right, so now let's talk about the second case. This is a case of a rape. And Pratiksha Bakshi has written this article. And here again, it's because it's an ethnographic study and she's looking at one particular case. And what is she trying to say? It's very, it's a little difficult for me to figure this out. But what she's saying is that this idea of a compromise is not really permitted in the legal rape cases. Now, whether this is true or not, you can tell. So out-of-court settlements are allowed in most cases, and you have a dispute resolution is possible, bargaining and mediation in the court and outside the court is possible. But in the case of rape, apparently, you are not allowed to come up with this compromise. But and then there's some other things that she uses, terminology she uses about crime, which is compoundable and non-compoundable, and this is what she calls a non-compoundable thing. We'll just go into that in the next slide. But then what she says is in this particular case, what she found is that there is this culture of compromise, which is pervading this whole criminal trial. And within the court, there is this kind of a conflict or contestation between the accused, the complainant, and the complainant, that is the person who has filed the case, and the prosecuting agencies on how to arrive at an out-of-court settlement in a situation where you can't. And then ultimately, the kind of solution they come to is quite a fascinating case, a fascinating account that she gives of this particular case. So this Pratiksha Bakshi has been following this case for some time. And she has written an earlier article also in 2005 about one particular trial of rape, abduction, and kidnapping, which was documented in the trial court in Ahmedabad. So she says, and this you can verify with your lawyer friends and faculty, that in the Indian criminal law, you have two categories of law. What they call compoundable and non-compoundable. And rape is what she says a non-compoundable crime, which means that the accused and the person who is petitioning, the opposing parties, cannot bargain and settle out of court. Thereby settle out of court, which can affect the outcome of the trial. So basically, I believe that this kind of a non-compoundable crime is basically so that to protect the rape victim. And this is what she says is not, is sort of even though it is a non-compoundable crime, they do come up with a compromise solution. And that compromise solution is what she's calling this culture of compromise. And how do they arrive at that? And why do they arrive at that? Is the study that she is talking about, is her research idea or topic. So it's an ethnographic account again, by way of testimony of how this compromise occurs. And in the case where this kind of a thing is not possible, they are arriving at this compromise. And this is seen as giving some kind of a social justice. That is, they're looking at this case not as a case of the court views this case, not as a case of one individual who was abused, but as a case of the society at large. How does the society look at it, and how would the society look at that particular family and so on. And hence they arrive at a compromise, and the court actually permits them to arrive at this compromise. So this is a truly ethnographic study with just one case, but it's a method. And this method, if you want to write a thesis, you can't write a thesis on one case. But if you look at a number of rape cases and see what actually happens there, then you might be able to arrive at whether what this lady is saying is true or not, the case of compromise. So actually what happened, it's very simple. The girl disappears with this boy for 5 days and then she turns up. And in the meantime, the father registers a case. Then when it comes to the police records, this girl gives 3 statements. And in these statements, what she's saying is changing. It starts from, saying that there was a case of, abuse, and to turning hostile. And then finally even denying that the event actually occurred. That this whole issue of going with this boy for 5 days and so on, whether that occurred at all. So you get this different kind of statements being recorded at different points in time. In the meantime, because all these cases take a lot of time, this guy had registered, the father had registered this case, an FIR was filed. This girl is married off. And then once she's married off, they don't want the married family to know about this. So the case comes to court finally because of the various delays and so on, after she is married. So now how does one deal with that? So in order to keep this a secret from the marital family, a compromise is worked out. And in that, the court, the lawyers, the person who filed the complaint, which is the father, the girl herself, all of them enter into this kind of what she calls a kind of a public secret. And in the questioning, when it's happening in the court, they actually don't talk about this event at all. They talk about her visiting her uncle's house. She denies when the accused is pointed out to her in court. She denies that she even knows this guy. And there is no real record of the abduction or the rape. And finally, the accused is let off. So this is what is happening in this. This is what actually happens in this case. So the way she understands this, or the way she researches and finds out, tries to understand this kind of a situation of a compromise, when a compromise in rape case is not allowed, according to her, she points out that this court then becomes a site, that is a place where a secret is kept, or rather a public secret is negotiated. She shows how the different actors during this trial over time actually agree to hide even the meaning of this rape, and so that this whole point, this whole event goes unrecorded in their legal records. So the operations of this, what she's calling public secrecy, she tries to find out through this method that she's using, which is my emphasis here, the socio-legal ethnographic study, looking at the legal records, talking to all these people, including the girl and the father and the accused and the lawyers involved in that court. And in this whole process, what she discovers, or what she draws attention to, is how there is this culture of compromise which underwrites the whole process of this rape case. And she terms this culture of compromise and emphasizes how a criminal trial becomes a site where the different parties are actually arguing or trying to get the best for themselves, and arriving in an out-of-court settlement, which is not allowed within the court between the accused, the complainant, and the prosecuting agencies. And this whole process, which she sees happening, or she doesn't find the records of, is what she calls this culture of compromise. So the court records details different versions. First and foremost, it starts with the different versions that this girl is giving, the statements, starting from the fact that this happened to the turning hostile, and then even saying that such an event never happened. And then when they come to court, they actually don't talk about the event. They talk about the girl going away to her uncle's house. So all in all, they kind of obscure the whole event And the court records also gives this politics of ambivalence of the two versions, and they create these versions of what actually happened, what the lady actually says, so that if required, there is a potential for the father who has actually filed the case, who is the complainant, to use in future. So, so she arrives at this result, basically, that the laws of rape, kidnapping, and abduction situate violence in a realm of a collective rather than looking at the actual case of an individual woman and her experiences of coercion or consent or whatever it is that happened in that event. Instead of that, it becomes a societal issue. It becomes an issue of how do we keep this a public secret? How do we not, create this kind of a situation? Of course, this is a much earlier case because this is a case in 96, 97. Whether this will happen now, it probably still happens in a lot of states. And maybe we have much more aggressive trials now. So this is another of the ethnographic studies which I thought was really very interesting. Because using this kind of material, following this trial, talking to these people, which is her data, right? So her ethnographic study is the interviews that she's taking with these people, the records that are there in the court with regard to this, and what actually the judicial process which actually happens in the court. That is the process on which. All right, so. Anybody would like to ask something with regard to this case, which is, quite a difficult one to understand and comprehend?
Ma'am, I had a question, if I may ask.
Yes.
Ma'am, for example, in qualitative researches, there is definitely less of cases and in-depth study, right? So what is then the reliability of the theories that we arrive at? Because generally we cannot use them.
Yeah, that's a very good question. So now this is a question that we economists always have, because economists who are very empirical, we use very large data sets so that there are a lot of records, whatever it is. So the number of people that are interviewed or the number of records that you have is very, very high, as you will see later on in the two studies that we go on, at least on one of the studies, the labor regulation study. So then we say, okay, there is a validity because of the statistical fact of this thing of large numbers. So large number, if you're using large samples, then you get a better truth than if you're using very small samples. But these kind of cases also tell us, so very often in economics, they also do these kind of studies. But more often in our kind of research, we use these studies to arrive at a research question or to really understand the nuances of what is happening in the particular event or study that you're looking at, and also to be able to explain what you are actually finding in the data. So even when we use very large study, you can always use a mixed methods thing. Okay, incidentally, that's also very popular. We call it mixed methods. That is, you use both quantitative and qualitative data. So even suppose you look at all these legal records and you arrive at a very large data set, quantitative data set. Even then, to be able to understand why that particular thing happened and how the actual participants in that behave, the way they behave, as it is seen in your large sample data, for that you would still need to do a number of, say, we call it focus group discussions or in-depth interviews with knowledgeable people. This is the kind of language we use. So it is also a method by itself. So in economics, we use what we call PRA and also focus group discussions and so on. So in a focus group discussion, you are basically getting together a group of people who may be similar or different, and then you discuss a particular issue. So if you're talking about this case, like the not the particular rape case, but the way rape cases are, compromised in a village or in a town or whatever, you can actually get information from a large number of people who might know about a large number of such cases in a group discussion. Of course, a rape is something too personal to be discussed in a group, but if it is the street vendor thing, you could do that. So this is also used as a method. Now you're asking me, the question you're asking me is very relevant, that how much can we say that this result is true, because it's just one case. So she's telling you that this kind of a compromise situation happens in rape cases. Now, if you can use that as a starting point, it can be your hypothesis whether rape cases are ultimately arriving at some kind of a compromise solution rather than actually prosecuting the accused, right? And then you can take up a series of rape cases and look at them both from the just legal records or from ethnographic work of this kind, right? So it can also be used as a method of arriving at some kind of a story that you would like to tell, the beginnings of a story that you would like to tell. We would call it a hypothesis or something. So it is a valid form of doing research as well. And in fact, ethnographers, anthropological research is done in this fashion itself. Yeah, you're right. Somebody says that it is part of a larger work. Yes, which is true of Karthik Rao's work also, which is true of Bakshi's work also. This is just, this could be like one chapter in your thesis, and then, you know, you develop it into getting the larger part of this. Okay, I think we are really running out of time, so I do need to go through the quantitative research methods. Okay, so we're going to look at two papers if we have time. Since I'm more comfortable with these, I could move faster. So the first one is about the Insolvency and Bankruptcy Code, which has come out in 2016. And these are like early cases which were filed for bankruptcy and for, you know, getting back the credit, the debt filed by creditors against the debtors. And the other one is on labor regulation. All right. So to look at the first case, one strand of literature looks at the judicial processes, like increasing efficiency in the courts, increasing efficiency in tribunals, which are looking at some particular kind of law, and reforms required. That's one strand of the literature. So again, like I said, you first go through a review of literature before you decide what you want to do. And another way of looking at it is looking at the judicial process and how good or bad it has been in terms of how delayed it was, how many cases were there in the civil courts, and so on and so forth. This is all coming from the records. So this thing has been cases in civil court. It has also been done for tribunals, like, for example, debt tribunal. In this particular paper, this group of Chatterjee and et al. Are using the National Company Law Tribunal, the cases which came up there, and trying to assess the judicial efficiency of this code under this new law, which is the Insolvency and Bankruptcy Law. Right? So he has what is it that he's trying to ask? That and why does he want to do this research? Is because it's a new law, and when it is actually changing from an older law. The older law was called the Recovery of Debt and Bankruptcy Act of 1993. But that 1993 Act was more like going to sort of trying to recover the money that was credited to them. That was what it was, a kind of a recovery kind of an act. But in this act, it's a slightly broader one, which is trying to encourage entrepreneurship. So you're trying to arrive at, okay, if you're in such a bad condition, then you can declare bankruptcy, and then there are methods that are arrived at in order to be able to dissolve that company. So and then what happens to the creditors and what happens to the debtors? So the frame of that law has changed from the way it was visualized in this Recovery, Debt and Bankruptcy Act to this new law, which is the Insolvency Bankruptcy Code Act. So obviously the old law was during the old regime, and the new regime is where we have opened up the economy, and we are trying to encourage enterprise, private enterprise. Private enterprise is the important thing which can lead to growth of the economy. Okay, so when that kind of a legal framework has changed, then you're trying to see the efficacy of this new law as compared to the old law. That's one thing. And then the other thing is that what was your expectation when you put up this law, the IBC law? And based on that expectation of that IBC law, how is it performing? So you are, is there a gap between the expected and actual outcomes? And this research is critical to identify that and how you can change that gap. I mean, how can you close that gap? So basically, he argues that the bankruptcy policy cannot be rooted in the reality until you have empirical evidence about the bankruptcy, and it has to be. So basically, he's arguing for very good data to be collected with regard to the cases which are being filed and so on. So unless and until you do that, you can't really judge the efficacy of this new law and of this new institution. This new institution is this National Company Law Tribunal. All right, so that is the purpose of his research. Now, his broad research question is to understand what has happened under this law, what are the outputs, and what does it mean for the expected outcomes of the law. Just what I explained just now. So what he does is, so now this is a classic case of a manufactured data set, where he is creating a data set using these, the databases coming from the, under the IBC, from the NCLT and from this National Company Law Appellate Tribunal. So both these tribunals. So he collects this data set of insolvency cases disposed of by the IBC, and he hand collects. That means he actually collects this information from the orders, and so this is basically coming from their websites. So what is it? What is the information he is getting? He is getting information with regard to when the case was filed, the date on which the creditor actually sent that notice to the defaulter or the debtor. What are the characteristics of the filing in terms of who filed it, what was the amount, what was the nature of the debt, and so on and so forth. And what was the response of the NCLT? How quickly did they take up this case? How has it been disposed of? What was the outcome of that petition, and so on and so forth. So all these variables are in some sense what he calls categorical variables. Now, what are categorical variables? They are mostly a yes-no kind of thing. So it's a binary variable. So you can give it a value 1, 0, and that allows you to manipulate it quite a lot through various statistical systems. So some of the data, though, like for example, the amount of debt and so on, was numerical in the sense that you actually know the amount of the debt in rupees. All right. So this is the data set. Now, I'm not going to show you the data. The paper is showing you the data. How for each of the questions that he asked, he shows little small tables for the data. So I will go directly to the questions that he is asking and the result that he is getting. So he is basically looking at two things. One is, did this IBC law create a shift from the debtors being, having an upper hand to the creditors having an upper hand or not? Because basically one of the criticisms against the earlier RDB Act, Recovery of Debt Act, was that it was in favor of the debtors. So the creditors were never able to get their money back. So here, did that happen or not? So his first question is there a change in the balance between the rights of the creditors and the debtors under this IBC Act, the new IBC Act? So because the regime previous to the IBC Act, which is this Debt Recovery Tribunal and the Recovery of Debt and Bankruptcy Act of 1993, the rights of the creditors was very weak, particularly of unsecured creditors, that whatever that is. And the data here indicates that there is a shift and the enforcement of the creditors' rights becomes stronger under this IBC. All right, so that was his first question with regard to the broad theme of shift in the use by the credit market participants. The second question he asks is that, do the right of the creditor under the IBC extend to various types of creditors of the firm debtors? So there also he says that all the creditors have shown the ability to be able to trigger insolvency. In the previous regime, it was only a set of creditors who could ever file a case. But in this case, all kinds of creditors, small, big, large, famous companies, not so famous banks, and so on and so forth, are able to file cases. So it's a much more open system, so to say. The third question he asks is whether the IBC is able to trigger insolvency resolutions for all size of debt. That is, if it is a small amount of money, I mean, nothing is small here. It's always in. So here he comes up with the answer that is true, that every kind of size of very small to very large debt cases were coming up. The creditors were able to trigger cases for a wide range of defaults. So, and then he has this threshold level of 1 lakh, and out of that 75% of cases were 10 to 100 times greater than that. So that is the first set of questions that he has, which he's looking at, which is in terms of the balance between the creditors and the debtors. How has that shifted with the new act? In the second case, he is looking at the functioning of the tribunal itself. How is the tribunal functioning? All right. So his first question is, do the NCLT cases reflect geographic spread? That means are all the cases being filed only because this is a national law? So all the cases only being filed in Bombay, which is your commercial hub, or is it being filed everywhere? And he finds that it is being filed all over the country. The second question is, does the NCLT function within the timelines of the law? So one of the complaints against this debt recovery tribunal of the previous regime, of the previous act of 1993, was that they were taking inordinate delay in doing the cases, and sometimes these cases were never resolved. Now that doesn't go with the spirit of the economy today. Because if we want private enterprise, if we want entrepreneurship to grow, if we want the growth of the economy to happen, then these kind of cases have to be resolved very quickly. And that is the reason why they have brought in this new law, the IBC law. So now you can see that I'm speaking like an economist and I understand this economic law a little better. So what he comes up with is that there are no longer the long delays and pendencies which were recorded in the insolvency cases as compared to the earlier regime. And the last question, I think, is the role played by the NCLT. Is it as it was visualized by the IBC? So what was one of his questions? That is the law, are they getting the results that was expected out of this law and also out of setting up this new tribunal, which is the NCLT? So here he finds that it's not exactly all hunky-dory, whereas in the other cases, he feels that this law is doing better. What he's saying is that it still requires, each of the laws are filed, each of the cases and each of the data which is filed are filed in different fashion. So it's very difficult to really understand what's happening there. So he says that there is a big gap there in what is required under the law and what is actually delivered by this tribunal. So what they require is a much better standardization of the way records are kept and improvement in the information recorded for every single order issued, every single case filed, and so on and so forth. Because unless and until you do that, you're never going to be able to tell whether this new law is of any use or not. All right. So now we go on to the last one. I have only 4 minutes more. But since we started a little late, I hope it's okay for you to go ahead and just wait for a little longer.
Yes, sir, we can continue.
All right, thanks. Okay, now this one is more in my line, which is, can labor regulation hinder economic growth? Also, this is a little older article and it has been criticized very much. And now, incidentally, while we are on this, and since I'm a labor economist, let me also say that everything has changed in labor law. So as you all know, they have kind of created these labor codes, 4 labor codes, and the labor codes have sort of, pulled together like hundreds of labor laws which were existing. So everything has changed as of now, and there's a lot of criticism against the new labor codes. So I think a very, very fruitful area of research for all of you, sorry, I am a labor economist, so I'm bound to say that, is looking at the efficacy of these labor laws. Sorry, this is the noise from my campus. So the paper investigates the industrial relations climate in an older period. Okay, now 1958 to 1992, before the economic reforms. So it's a totally different era when there was a lot of labor regulation, a lot of so we had the Industrial Disputes Act of 1947, which was the one central legislation which was used, and he looks at and which this Industrial Disputes Act looks at conciliation, arbitration, adjudication in labor cases. All right, in an industrial dispute. So it's basically related to the formal sector, the organized sector, and mostly in the manufacturing sector, because in those days the service sector had not developed in the fashion in which it has today. And the act was supposed to help the workers in the organized sector to get some kind of legal protection against exploitation by the company or the employer. So now, how does he do this? This paper is considered a very seminal work in economics and law, where he actually codes labor regulations by looking at state level amendments to the Industrial Dispute Act of 1947. So at that time, at the time when he did the research, there had already been 113 amendments to the act. And the states are also allowed to amend these acts. So what he sees is the point of departure of his study is that when this thing started, when the law first came into being, all the states were on the same plane. But over time, the amendments that the states came up with made them diverge from one another. So he actually codes that divergence. And how does he do that? Each amendment is coded. Each amendment of the act, sort of these 113 amendments that he sees in different states, he codes them as being either neutral to the worker, for the worker, pro-worker, or pro-employer and against the worker. And then he of course he has to take a call as to whether that amendment is pro-worker or, and there of course he makes a lot of mistakes and there's a lot of criticism against this. There's a lot of criticism against this particular paper, but the method that he uses is very interesting. And like I said, my focus is basically on the methods, and the rest is for you to decide how to do anything. So what he does is that he codes these amendments to this act as pro-worker. So if it is pro-worker, it gets the value 1. If it is neutral, it's 0. And if it is pro-employer, then it gets the value -1. So basically what it means that higher the value of this particular code, labor regulation variable that he has created. So he's basically created a variable, and that variable is labor regulation. So the higher the value of that code, the more pro-worker is the legislation, is the amendment. All right, and then he shows which states are pro and pro-worker or pro-employer. All right, and then there is this other part of the method that we use in economics a lot, and you could use it here too. It is classifying the states as treatment or control. So now, what does that mean? That means that a control state is a one which, between this period, 1958 to 1992, had their amendments were neither pro-worker nor pro-employer. It was kind of a neutral. So that will be used as a control. And then whatever regressions you run or whatever analysis you do, it will be in comparison to this neutral thing. And the other treatment, so the other states were recorded as being treatment states. And there he had two. One is the pro-employer one and the pro-worker one. So he codes, so as you understand, so this is just one variable being created. And this one variable is your what we call an independent variable, which affects various types of outcomes. Okay, so when we do research in economics, we always have an equation, or at least in your head you have an equation, and in that equation in the head, y is the variable you want to analyze. So that y variable will be your dependent variable, and you are seeing what are the variables which affect it, and those are called independent variables. So, and those are the x variables. So y is equal to a function of all these x variables. So y is the outcome you want to look at. So the outcome I want to look at is whether workers are better off or worse off, right? And what is this? Labor regulation is your independent variable. And is that independent variable of labor regulation, how is it affecting the your outcome variables that you want to understand? That is how you will interpret this. All the other studies that we did, even the ethnographic, if I were to sort of think about it, then I would think of it in this fashion. So what is it that you want to study is your Y variable. And what are the things which are affecting that thing that you want to study, that outcome, are your independent variables. So whether you have an equation or you don't have an equation, if you think like this in your head, then it's easier to arrive at a research question and to arrive at, even being able to analyze this, whatever data that you collect. All right. So he ended up with, in this time period, 58 to 92, 6 states which were, controlled states. Just a minute. I have to just get up for a minute. Sorry about that. All right. And then there were 6, in the treatment states, he had the pro-employer, 6 states, which are these, and 4 states which were pro-worker. Now, you can very easily see that there could be a problem here, because if we think about pro-employer, would anyone classify Kerala as a pro-employer state? One would visualize that as a pro-worker state. And similarly, when you say pro-worker state, how does one visualize Gujarat as a pro-worker state? I mean, it's generally for business and for enterprises. So then that's some of the criticisms which come against him. Okay. Now, these are the variables that he uses. Now, out of all these variables, only the first variable is the independent variable, that is the labor regulation variable that he just created. He is going to see the impact of that labor regulation variable on all these other variables, which are outcome variables. All right, so I'm not going to bother you with all of them, but I'll show you one equation that he does, so which is this one. So what are we interested in? The impact of this labor regulation on outcome for workers. So what are the things he has taken? Work days lost in strikes per worker and work days lost to lockouts per worker. So, and then he finds this positive relationship. That is, if the labor regulation is more pro-worker, then you are likely to lose. It's a positive relationship. So these stars show that they're all significant. So if the labor regulation is more pro-worker, because if we go back to our, if we go back to this, the pro-worker is equal to 1, right? And the pro-employer is equal to -1. So higher this value, the higher, the more likely it is pro-worker. So if the amendment is pro-worker, you're going to, it's a very unintuitive kind of a result. You're going to get more lockouts, which is true if you're more pro-worker. So what does he get finally? He finds that, and then he has a whole lot of other variables, like for example, urban poverty. He looks at urban poverty. So if you look at all these variables, so these are all worker lockouts and so on. And this is, registered manufacturing and unregistered. So the arrival of informal sector being increasing, which is not considered a very good thing. And then whether urban poverty is increasing. So all these variables, whether labor regulation in the state is affecting all these variables, is what he is looking at. And then he arrives at these results that having a pro-worker state experienced lower output. So it was going against economic performance. It had lower output and lower employment and lower investment and productivity. So overall, it was bad for the economy, which is what they like to. Employed people would be very happy with that result. And then it encouraged the increase of the informal sector, which is again not a good thing. And also he looks at urban poverty, and he finds that the pro-worker places were associated with increase in urban poverty. Again, not a very good result. So he suggested that attempts to redress the workers by giving them a pro-worker thing was not necessarily good for them, because it was increasing informal employment and it was increasing urban poverty. So that is the kind of result he comes up with. And finally, There are a number of studies which sort of criticize him. Bhattacharjee is one of them. So what he says is that the way he has done the scoring of pro-worker and pro-employer, like I said, they object to it. Like, for example, Gujarat has been seen as a pro-worker on the basis of one solitary amendment in 1973, where a penalty of 50 per day on employers was charged. Now that alone has given that a pro-worker position, which he says is not wrong. And similarly, he takes up the Andhra Pradesh case and also shows that when they show Andhra Pradesh as a pro-worker tag, these incidences that he's taking are not really good enough to categorize that state as pro-worker. And similarly for Madhya Pradesh. I think, thank you. And I think the rest of it, you can okay, of the sharing.
Ma'am?
Yeah, have I managed to get out of the sharing? No, right?
We have not yet.
No, ma'am.
Okay, how do I do? Oh, stop sharing. All right, sorry, that was really very long. I hope I still have my participants and all have not disappeared.
No, not at all. One thing I would like to say is, see, your approach was very wonderful. We in law, we do not take up this type of approach. Case by case approach. We take case law as a part of study. But we see the comparative study of the development of the law or the need of amendment and the impact of amendment. But the way you have put it, in that how samples can be taken, how it, I mean, this was an eye-opener for me for taking up research in this line for me. I'm really thankful to you for this approach. I mean, one thing with research is you could be doing, I could be doing, everybody could be doing. But there is a different way in which we do the research. So learning from each other really helps us to understand and appreciate our own work. I think that is the beauty of research. Thank you very much, ma'am. Thank you for spending your time, your energy, and your wonderful research that you met your own friend.
I didn't get Usha to say anything. She disappeared, is it? Yeah, so hi Usha, I hope you found it interesting.
Very interesting. Give you the vote of thanks. Just wait a minute for it. But yeah. From my side, from my personal this and the GNLU PhD department, we are really grateful to you, ma'am, for your time, your energy, your research, your interaction, your sharing. Wonderful. Thank you very much, ma'am. Dhanya, who is doing the vote of thanks?
Do you have anything to say? You're muted.
Dhanya, ma'am?
I think they've already reached the vote of thanks. I think if I say anything now, it will delay them further.
No. It is a duty they have to do. So they'll definitely do it.
Usha ma'am, if you have anything to contribute, please go ahead, ma'am.
No, actually, it's just a brief kind of thing because listening to Jeemol, I was thinking the way we have to do our work is necessarily, I find the jury matrix, for instance, that doesn't work for us. It's been attempted and it didn't work. But what you said, for instance, in Pratiksha's, that single case that she picked up, it's exactly what you said. We know what a research question can be when we look at something like this. For instance, we've had changes in the law on hostile witnesses. And, witnesses turn hostile in situations like this. And in criminal law, the state takes over the case. So it is no longer just your case. And we have, questions of hostile and we have questions of perjury. So when these matters require resolution for a person rather than decision, then it's complicated. So we do need to know what the law does to people in situations like this. And we also know that people are made to become hostile because of the pressure of the accused. So how does law deal with these contradictory kind of pulls? It's something that I draw from the cases that you've given us. There is a lot actually that we take to what you said.
Dhanya, ma'am?
If anybody else to ask questions.
Anya, ma'am,
Yes, ma'am. Yes, ma'am.
who is doing the vote of thanks?
Oh, ma'am,
Ma'am,
this is Keith
ma'am,
and ma'am. I'll be
Just a
doing the
minute.
vote of
Before
thanks.
vote of thanks, would anybody like to say something? Because I see in the chat people asking for a question. Does anybody want to say anything?
yes, ma'am. Nadim sir, if you can unmute yourself and ask your question, please.
Yes, Nadim.
I have two very quick observations and a question. One, I think Usha ji has clarified about the Pratiksha's study, which is now published as a book. So, because there was a question regarding generalization of a kind of qualitative studies. So, it depends on the analytical framework. If your analytical framework is in place, one can generalize to a large extent. Even the qualitative study, like the way Pratiksha has done. Second is that there I see in this what is this the labor law study, there I can sense a problem in the definition of the whole pro labor and pro employer definitions or terms, and therefore the criticism.
Yes.
And therefore, as you have already pointed out, that how, as in Gujarat, figures in a pro-labor strand, and therefore that study for me is a very wonderful vis-a-vis the methodology, but has a little weak on the definition part. These are two observations, and therefore it is important for researchers like us to resolve the definitional issue and get a feedback from experts like you at the definition stage.
Jeemol, can I just say one more quick thing?
Yeah.
So, you know, in law, we are constantly conflicted about how much economics, how much sociology, how much history, how much do we need to know these other disciplines? And there are two schools of thought in jurisprudence. One, which in relation to judges, they normally say, they say that, you know, one set say that judges need to know something about all of this, and others say that no, you need to know how to have the process of judging into which all this will come, because largely it's an adversarial system. I think, you know, the method that you produced for us is useful in the sense we do need to know economics. I mean, my complaint about economists very often is that they just don't know the other disciplines. And I think in law, you can afford to know it, I mean, not to know it even less. We need to know it. And one other quick thing, which is that, you know, we have this whole thing called judicial impact assessment, which is about what is the impact on the judicial system when you have a new law that has been introduced. So the IBC case, apart from what it is directly telling us, is also giving us fodder for us to think about what happens when a new law is introduced. Just making of a law is not, it's not a neutral event. It has all kinds of consequences and implications other than what it does, you know, for what it is supposed to deal with. It has a huge implication for judicial delay, for you know, spreading your resources much thinner, and a whole host of other things. So there's a lot to think about in, you know, in these studies.
Yeah. So all of these studies are not. I mean, I don't, you know, accept any of these studies. Okay, I'm just giving them to you as different, you know, cases of different methods that can be used. And you know, it's like the IBC case, for example. It's, you know, you set up a law, and then okay, all you lawyers just go about implementing that law. But you know, what does it do? I mean, what does it actually do? That is what you people as PhD students are supposed to tell. Then only that, you know, if I say that it has less impact than if you do a study of that kind and you know, are able to say from your law college that this is what this particular law is doing. And similarly, you know, if you want to go down to things like street vendors and all, there is that act. I mean, we as sociologists and economists, we are always trying to figure out, has anything happened at all on the ground with regard to that? But then you as lawyers can, you know, come up with many such laws which have recently been, because so much has changed. And labor codes is really an issue today. A lot of the rights of labor have been taken away by these new labor codes. So what is it doing? What is it doing to the workers? What is it doing to the employers? I mean, so there are hundreds of questions that you can, you know, think about, and you can do. And then this is just a few methods. You'll have to figure out your own method best for you. All right. Thank you very much. If anybody else has any questions, you're most welcome.
Do we have any other question? Okay, so ma'am, we have one of our scholar ready with the vote of thanks. So may I request K. Kirtan Shenoy to please conclude the session and deliver the vote of thanks?
Yes, Dhanya ma'am. Ma'am, am I
Dhanya
audible?
ma'am, before you conclude, let me ask, ma'am,